Yes, hello. This is Georgianne Ford with the Alpha Center for Divorce Mediation. And we're here today with one of our attorney mediators returning to us. And Christine Lombardo-Zaun is going to be speaking to us about how important it is after the divorce to look at our estate planning. Is that right?
Well, and even during the divorce. So during and after, depending on when you're watching this, it's applicable to all.
Okay, well, we are all ears because it sounds like something we really need to be aware of. So please fill us in.
Thanks, Georgianne. So yeah, this is a really interesting area. A lot of people have been asking about, when should I do my will or when should I update it? And, with my mediation clients, it's not really a problem. We kind of guide them and keep them on track, and we refer them out to attorneys who can draft wills and powers of attorney. But there's a lot of traps that people fall into, and if they don't have that proper guidance, it can become very troublesome. I just read about a case where the husband and wife were going through a divorce. And I think this was in a different state. So I practice out of Pennsylvania mostly, but husband died while the divorce was pending. And yes, while he was going to leave her everything, all of that blew up. And she had to basically sue in orphans court, but it basically nullified the divorce. And she, instead of being a divorcee, became a widow. I think she did get some of his estate because they were still legally married. And then his relatives kind of had a battle because they knew that these parties were divorcing, but yet wife was going to get a big share of the estate. But she had to fight for it.
So how does it if someone does pass, does it just automatically assume it's going to the name?
So normally, yes, like when you're married and if one spouse passes, everything goes to the other one. When you're going through a divorce, if one of the things we do is we draft settlement agreements. And in that settlement agreement, you give up your rights to the other person's estate. But that doesn't necessarily take care of everything. And so there's a couple things that you have to do to kind of protect your assets, because God forbid, if someone dies during the divorce litigation, you might not be able to get divorced, or you might have to spend all this extra time and money to get what's rightfully yours. Even if you have a settlement agreement, but the divorce isn't final, there is a chance that, and if one spouse dies, that the divorce would stop automatically and cause problems. So I came up with a list of a couple things that people should do during the divorce process, right? Like maybe you're in that 90-day wait period.
And are these things something that we go through in the mediation process?
So we don't, as mediators, we're third-party neutrals. We don't represent either side, but we certainly can refer them out. I have clients who, they're like, yeah, we have to get our wills done. So, I have a referral base of attorneys depending on their location. And it's nice to refer to, attorneys that specialize in that, and that are also local to their geography.
Right.
Because of local rules. So, but we guide them, of course. We say, here's your resources, go forth and make a will. And nobody wants to talk about this. This is like kind of a gory, gruesome topic in a sense. No one wants to talk about dying, and no one wants to talk about the what ifs, but that's why lawyers are here, because of all those what ifs that actually happen. So one of the things, and I just want to preface with it, is most of the state laws have a provision that if you're divorced and you haven't changed your will, if the ex-spouse dies, that person isn't going to get everything, okay? Because the law will presume that the ex-spouse died before you, okay?
Is that in Pennsylvania or most states?
That is in Pennsylvania. Now, you have to check state laws because every state's different. Now, the thing is that, well, okay, that's great, but what about all these other phases? You know what I mean? And you don't want to just bank on state law. So if you don't have a will, you should absolutely have a will. And I tell all my clients, if you own anything, you should have a will. The will is a document that tells the court, the state, how you want to leave your property, to whom you want to leave your property. It also identifies the person who is going to administer your estate, right, and handle your affairs after you pass. Also, if you have minor children, okay, you need to probably put some provisions in there, maybe a children's trust, and then if so, who's that guardian going to be? Who is the children's personal guardian, property guardian? There's things that you have to put in there. So having a will is the first and foremost thing. They're not that expensive. Mm-hmm. If you go to a boutique law firm, yeah, you're going to pay a lot more. But there are plenty of local attorneys that are solo practitioners that do great work at a very reasonable price.
That's very helpful.
And they do that because they really are passionate about what they do. So I found them to be the best resource. When you talk to that attorney, they're most likely going to tell you that you also need a power of attorney. And that's a dangerous document because it's, you're giving somebody the rights to handle all of your financial affairs if you become incapacitated. So this is while you're living, but you're not able to, let's say, pay your bills or make decisions. This person steps in and acts as your fiduciary or what we call person of trust.
Mm-hmm.
The problem with that, go ahead.
I'm just wondering, and I get very confused on that. Does that include the health decisions?
Okay, so you have your financial power of attorney, or some people will call it a durable power of attorney. There's a few different kinds. Really what that means is the durable is most common. And, if you were my power of attorney, as soon as you sign that document, you could literally go clean my bank account out. Mm. Problem is there's laws out there and you'd get arrested and go to jail, right? Because you're not acting in my best interest. So that's you have the will, then you have the durable power of attorney, but then you do have a healthcare power of attorney. So it's a different kind of document, but it's the same flavor as the power of attorney, where you're giving someone that power to make healthcare decisions on your behalf.
So that's something with a divorce that's often changed as well, I'm guessing.
Well, think about it. People that are married, do you want your ex-spouse making decisions about your health? Probably not, because if it's not a great divorce, they're going to be like, yeah, let her go on the table. You know what I mean?
Unfortunately.
So you really want to find a person of trust. I always use that example. You don't want to go to the hospital during the divorce, because what'll happen is if you don't have a will, if you don't have a power of attorney, the hospital staff, they're going to go to what we call next of kin, which would be your spouse. Mm-hmm. And I think even if you're going through a divorce, they have to defer to that person.
Imagine that causes some real problems.
Yes.
So if that was clear or changed during the divorce process, would that help?
It would. Okay. And, one of the things that you can do is, there's checklists out there. If I had time, I would create one. I need 3 of me to help me with that. But
this is so helpful already.
It is good information. I'm very passionate about this because over 70% of our population does not have a will. And it causes problems. It causes extra time, extra money, extra stress that none of us can afford. Now, once you get your will, your power of attorney, and even your living will done, okay, these are all documents that an estate attorney can do for you. You also want to change your beneficiaries. So I don't know about you, but I've gone through, a few career changes, and I've worked at company A, B, and C, and, I've had retirement accounts with each of those companies. Now, what happens is sometimes those companies are bought and sold without us really knowing about it. It's that stuff you get in the mail that you don't read. You just rip it up and toss it. When that happens, though, sometimes in the transition of the companies, they erase all of the beneficiary information. And if you die without beneficiaries, it could be counted as something that needs to be taxed or probated.
Mm.
Okay. So one of the things you can do, and I recommend every 5 years you go and you look at all of your accounts and you update your beneficiaries. Might even want to do it, like the older you get, maybe every year. And it takes 2 minutes. You might also want to keep a list of all of your assets and where they are, because God forbid if something happens, you need your person to know where to find all that. So I know I'm kind of getting off track, but some of the financial instruments are like 401ks, IRAs, CDs.
So, Christine, what if I already have a will? How do I change it? Like, what do I have to do to say, I want to change this will?
Well, there's 2 ways to do it. So, I have found you can write a codicil, which is a change, an amendment, which is probably the least expensive. But if a lot of people, what I'm finding is they don't remember the attorney that drafted the original will.
Right.
So then you just you rip up and destroy the original will.
Mm-hmm.
And you literally have to destroy it. Okay. And then your new will say, I hereby revoke any previous wills, and you just start over. It's a lot easier, I think, for attorneys, to be quite honest.
Mm-hmm.
And then there was trying to think. I could go on and on and on about this, but that's kind of the big thing.
Yeah. So I'm sure other people are taking notes. I was taking notes. So it's about protecting our assets and being aware of the fact that things are changing, and we want to make those changes to show up where we really want our assets to be going, and our money and our insurance and our benefits. And
the other thing is the HIPAA. You know what I mean? When you go to the doctor. And this is especially important for, couples that are divorcing that are older, that go to the doctor more often, or, someone that might just visit the doctor more often. That should be kind of like number one on your list. Change your HIPAA designations, and, get your spouse off of there and put somebody you trust. Now, I do have to caveat, because I really do try to be positive. And there are couples out there that want each other to stay on as the representative. Mm-hmm. Even life insurance. I have some couples that, because they have young children, they each take out a policy and they make each other the beneficiary or the trustee. Mm-hmm. for behalf of the children. You know what I mean? Mm-hmm. So, you don't have to remove the spouse, but if you don't trust that person, then you should remove them.
Well, I think that the whole message that we got from this, and thanks for your time, was to make sure we review these papers, and it's best to review them more often. And if we have them, to review them much more often, especially during a divorce and after a divorce. Is that right?
It is. And, I wrote about this and spoke about it. We're not firing on all cylinders when we're going through a divorce. Mm-hmm. And we're not thinking clearly. So, take advantage of the experts. This is when hiring a lawyer is money well spent.
Good point. And you had a lot of helpful hints for us. We've got good direction. So thanks so much. As usual, you always give us a lot of direction. Any one of you out there that are interested in talking to the Alpha Center for Divorce Mediation, you have questions for Christine on this topic, feel free to contact us at 1-800-310-9085. Anybody who has that phone will be happy to help you. And Christine is always available as well. So we look forward to hearing from you.